Test, test, test.
Chair, we are live when you're ready.
Want me to? Can you hear?
Order of the Cannabis Compliance Board set for today's date, which is September 28th.
Yep.
Have a roll call call for purposes of officially having a quorum.
Great. Start with roll call. Member Jerry Merritt. Member Dennis Nylander.
Here.
Member Rihanna Durrett.
Present.
Member Young.
Here.
Great. And Chairman Michael Douglas. Great. Deputy Bala, can you please confirm that we have complied with the open meeting law requirements?
We have Director Cannabis.
Thank you. So with your approval, Chair, we can get started by introducing agenda item number 1, which is public comment. Okay, great. So now open up to public comment. We will start here in Las Vegas. Is there anyone here in the room wishing to provide public comment? If so, please come up to the podium. I see none. So
Excuse me, please. This is the court reporter, and I am having difficulty hearing the chairman. I'm not sure if his mic is on.
My mic is now on. It's
Thank
now
you.
on.
Thank you. Thank you so much.
thank you. So now go to Carson City. Is there anyone in Carson City wishing to provide public comment? If so, please come up to the podium and state your name for the record. I don't see any public comment in Carson City. Chief Gilbert or Member Young, can you confirm that?
That is correct.
All right, great. Well, with that, Chair, we can move on to agenda item number 2. This is the consideration of approval of the meeting minutes. Chair?
We have on for consideration this morning our minutes from our meeting on the 24th of August, a regularly scheduled Cannabis Compliance Board meeting as item A. And we have on additionally item B, our emergency suspension meeting of August 26, 2021, which was a meeting via phone. We need a motion for that. They can be taken together or they can be taken separate. Just a matter of who wishes to make the motion and how they want to proceed.
Member Merritt, I motion to approve.
To approve both A and B together.
Yes. I didn't hear. Oh, I motion to approve both August 24th, 2021 and August 26th, 2021.
Thank you. Do we have a second for approval of both of the meeting minutes for the 24th and 26th?
Rihanna Durrett, I second.
We have a motion. We have a second. Any discussion, corrections? Hearing none. All in favor, please say aye.
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 Motion carries. We move now to our consent agenda. Item 3.
Chair, item 3A1 on the agenda concerns one complaint for disciplinary action pursuant to NRS 678A510. The Attorney General has reviewed these violations and has recommended proceeding with disciplinary action. Under 678A510-2, the board must grant approval to proceed with disciplinary action. So if approved, I will then authorize service of the complaint within a reasonable time. Once it is out for service, the CCB will post it on the website. So I'll now present the violations alleged and request the board vote to authorize proceeding with disciplinary action. As to respondent A, the complaint will allege multiple violations of NAC 453A and 453D and NRS 453 A and D, excuse me. Chair, back to you.
This matter is on for a motion to either accept or reject pursuant to revised statutes of this particular complaint that we as a board have not seen, but it's required to come before us. So do we have a motion?
Member Dret, I move to approve.
We have a motion for approval. We have a motion for second.
Member Merritt, I second.
Motion for approval and motion for second. Any discussion as to this item? Hearing none. All in favor, please say aye.
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 Motion carries.
Okay, great. We'll move on to agenda item number 4. This is a request for transfer of interest. I'll turn it over to Chief Dave Staley to go through this agenda item for the board. Chief Staley, when you're ready.
Good morning. Chair Douglas, Member Merritt, Member Nylander, Member Durrett, and Member Young. For the record, I am David Staley, Chief of Investigations for the CCB. I'm here to present agenda item number 4, which consists of 1 transfer of interest or TOI application. Item A is a TOI application for Taproot Holdings NV LLC or Taproot. TOI number 19070 is a withdrawal. TOI number 21000011 requests approval for an internal transfer of one of Taproot's conditional adult use retail licenses from one Taproot subsidiary to another. Staff has identified no areas of concern with this application. I am available for any questions, and my understanding is that Shane Terry is present to provide a brief presentation to the board and address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
If we can have council come forward and make their presentation, or if
Good morning. My name is Shane Terry, and I'm the CEO and managing member of Taproot. And I'm hoping this will probably be the simplest decision that we have to make this morning. As you recall, in the last application cycle, we had to apply for the dispensary permits under an existing entity. So as we start getting ready to open up our dispensaries, I'm just creating separate LLCs to move the licenses from the production entity into its own individual dispensary entity. So this is a transfer from an entity that I'm the sole 100% member of to another entity that I just created and I'm also the sole member of. And with that, I'll answer any questions.
questions by the board members?
I have a question, Mr. Chairman. This is Member Nylander.
Please.
Good morning, Mr. Terry.
Good morning, sir.
So it looks like this is this new entity. Are you going to form then, I guess, would be 5 other entities and
Yes,
eventually transfer all of those out to separate LLCs?
Yes, sir, that's correct. The intention is to create an entity for every separate geographic location.
Okay. And so we'll be seeing you soon again, that sounds like.
I hope so. Yes, sir.
Okay. I didn't have any other questions at this time.
Any other board member have a question?
Good morning. I think I would have heard of it by now if it had happened, but did any of these get open?
This is the first one that will be opening. It's in Humboldt County, and the city of Winnemucca actually passed regulations within the incorporated city, even though the county still has a moratorium.
Congratulations.
Thank you.
Any other board member wish to ask questions? If there's no further questions, thank you, sir.
Thank you, sir.
If that be the case, do we have a motion as to the request for transfer of interest?
Member Dret, I move to approve.
Do we have a second?
Member Merritt, I'll second.
We have a motion, we have a second as to approving the request for transfer of interest in regards to Taproot Holding. All in favor, please say aye.
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 Any opposed? Motion carries.
Chair Douglas, I apologize. Would the board please consider the withdrawal of TOI number 19070 as well?
We will take that in a separate motion since it was not part of the first motion.
Member Dret, I move to approve the withdrawal of TOI application 19070.
And do we have a second?
And then I'll second.
Any additional
Member
discussion?
Merritt.
Any additional discussion? Hearing none as to withdrawal. All in favor, please say aye.
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 Any opposed? Motion carries.
Great, Chair, we'll move on to agenda item number 5. This is the consideration for approval of management services agreement. Chief Staley will present on this item. Chief Staley, when you're ready.
Thank you. Chair Douglas and members of the board. For the record, my name is David Staley, Chief of Investigations for the CCB. Item number 5 is a May 5th, 2021 Management Services Agreement or Management Agreement between MMNV2 Holdings 1 LLC or MedMen and Mustang DeMals LLC or Mustang. The management agreement provides for Mustang to manage and operate all aspects of day-to-day business of MedMen's cultivation and production operations in Sparks, Nevada. Mustang will receive a management fee of 30% of net revenues. The management agreement has put in place pending the completion of staff's review of a transfer of interest application filed by the parties on August 11, 2021, in which Mustang has applied to acquire MedMen. CCB staff have reviewed the agreement and found it appropriate. CCB staff recommends that the board consider approval of the relationship between MedMen and Mustang rather than approval of the agreements themselves. I am present for any questions, and my understanding is that Amanda Connor and other executives are present to make a brief presentation to the board and address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Ms. Connor?
Good morning, Chairman, members of the board. I am Amanda Connor on behalf of Mustang DeMals, and with me today here is Alicia Ashcraft on behalf of MedMen Nevada 2. Via Zoom on our side, I have Andrew Creighton, President, and Zachary Kozak, Chief Legal Counsel. I'll let Alicia introduce who she has.
Hi, good morning. And on behalf of MedMen, we have by Zoom Senior Vice President of Corporate and Legal Affairs, Mr. Dan Edwards.
I understand this is MedMen and it's they're doing business here in Nevada and such. There was some interesting articles in the trade in terms of some lawsuits in California as to activity over there. Is that anything we should be concerned with here?
I don't believe so. Dan, are you able to address? I think there are some things that may be cleaned up, some leftover lawsuits, changes in officers and directors, but I don't think that that affects what's happening here. Thank you, Chair.
Board members, questions?
What is Mustang's past experience in operating cannabis facilities?
I will defer to my clients to give some information.
Hi, I just want to thank the board for its consideration today. So Mustang is a subsidiary of a larger entity, Foundry Works, and Foundry Works is made up of companies that have significant experience in cultivation in California, and we'll be bringing that experience to Nevada as well. Same for manufacturing. We are made up of entities that have significant manufacturing experience, and we'll be looking forward to bringing that experience to Nevada.
Board members, anything else that they wish to ask the parties or representatives?
Yeah, could you just give a little more detail, like where those licenses are located and any a little information about your successes?
Sure. So there are licenses in Mendocino County. Our heads of cultivation founded a brand called Lid House, and they are successful cultivators and licensed operators in the state of California. We also have, on the manufacturing side, licensed entities and successful operators, a brand called Sonder Manufacturing, Sonder Endeavors, excuse me. Sonder Manufacturing is the licensed entity. And then we will also be working with MedMen and the the current staff at the Mustang facility to make sure that there's continuity and that the staff that's currently operating will be remaining in place and becoming employees of the Mustang Two Mouths entity. So that should be a seamless transition.
Can't remember, is MedMen publicly traded? Is it listed? So these details would have been public anyway. Can you describe a little bit more detail this option to buy? Because it seems unusual. I just wanted to hear why that would be enticing from both sides.
Sure. So from Mustang's Two Mouths side, it's the intention is for this management agreement to remain in place until the transfer of interest application is hopefully successfully processed, at which point we will be exercising the asset purchase of the MedMen Nevada facilities. That the option is intended to take effect once the transfer of interest application is approved. At that point, that's the intention of the purchase option.
Can we hear from MedMen too?
Sure. This is good morning, everyone. This is Dan Edwards, as Ms. Ashcraft mentioned, Senior Vice President of Corporate and Legal Affairs at MedMen. I would second what Mr. Kozak said. And this transaction is also, it's a multi-state transaction. It's also taking place in California with one of our facilities here, a very similar facility in Desert Hot Springs, California, here as in Nevada. And as Mr. Kozak mentioned, this management agreement is in kind of an interim step into a larger transaction whereby they will exercise options, ideally on both those facilities, pending the transfer of interest application here in Nevada. In the interim, in the management agreement, there is a split of rents and revenues, of course, but as well as operating expenses. And from the MedMen side, this reduces significant cash burn off of our rent expense and our operation expenses, and allows our co-parties here, as mentioned, to enter the state into a great facility and to bring their expertise in products into the state of Nevada.
Is Mustang's parent company, is that publicly traded?
Yeah, so MedMen at the top, there's a company called MedMen Enterprises Inc., which is publicly traded on the Canadian Securities Exchange in Canada.
No, Mustang.
No, it is not. No, Mustang is a private enterprise.
Okay, that's interesting because that's one of the first transfers we'll have seen going from public to privately held.
Anyone else, anything else they wish to ask?
Just to follow up, Mr. Chairman, this is Member Nylander. I have the agreement here, but it sounds like there's no contemplation of an equity swap. It's strictly an asset purchase on the option.
That's correct. It's an asset purchase. We will not be purchasing the equity.
Okay, so when we see this again as a transfer of interest, we won't see any of the existing shareholders. It'll just be an asset swap.
That is correct.
Thank you.
Mr. Staley, additional question. In the report that we received, there was a notation that we make sure that what we're noting is that we go ahead, if we are going to approve this, that we're approving the relationship between MedMen and Mustang and not necessarily intricate terms of the management agreement.
I'm sorry, David Staley for the record. Yes, sir. Staff suggests that you recognize the relationship between the parties and not the terms of the agreement itself.
With that understanding, do we have a motion?
Member Durrett, I move to approve the relationship between the two parties under agenda item 5A, and the fact that they're entering an agreement, but not the content of that agreement.
Do we have a second as to this?
Member Merritt, second.
Any further discussion? Hearing none, all in favor of approval, please say aye.
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 Aye. Motion is carried. Thank you, and thank the licensees and the parties.
Thank you.
Thank you.
Okay, Chair, we can move on to agenda item number 6. This is the status report to the board regarding the receivership and potential transfer of interest requests by the receiver, Mr. Leonard Jr., and counsel for ACC Enterprises. Today we have Mr. Savage and Mr. Leonard here with us to provide the board at their request with a status update on the receivership as it sits now. So, Chair, I'll turn that back to you.
Welcome, and if you'll give us your report as to the status of this.
Good morning, Chairman Douglas and members of the board. I've spent some time out there at ACC, along with all these many LLCs that own parts and parcels of ACC. A lot of these transfers and purchases of interest were prior to 2020. I think it's appropriate that we do a transfer of interest. We can't do that yet because the minority holders here have questioned the legitimacy of transfers between Howard Mazel and his widow and the initial transfers or purchases. What we have planned to do, we have set up is mediation with Judge Gonzalez, and that is presently scheduled for October 5th. The parties are now trying to move that to October 12th, and Gonzalez is still available. If we cannot reach a resolution, we have binding arbitration between all the parties scheduled 2 weeks later. We're going to use Judge Peggy Lean. Now, what I've done out there, we're trying to got Shivas Datum, which we've retained to look at all of our compliance issues, and she's done a good job there. And I think that after the binding arbitration, we should be able to do a transfer of interest that would be acceptable to the board. It's inappropriate to do it at the present time because we'd have to do another one. John?
Oh, nothing further. I think you covered it.
Questions by board members? Hearing no questions. This was on for discussion only. It is a little convoluted, to say the least.
Excuse me?
I said it is a little convoluted, to say the least, as you're working out the details of the various parties involved, because some of the formalities weren't adhered to previously. We appreciate the work that you're doing to put this in proper order. Report was very thorough, and just our CCB staff, we were talking about receiverships, and there's a lot of good boilerplate in here to help us with some of the questions that we talked about last time in terms of things to look at. With that, though, questions.
I do have a question. I don't want to get involved in anything that would that you don't want to share because there's an ongoing court case, but in general, I thought this would be cut and dry because his interest would just be transferred to his wife. Why would there be a negotiation over who it goes to? Are there other members of the company vying for a larger interest in it?
Yes, ma'am, something like that. The minority interest holders are saying that because Mr. Meisel did not or cannot prove that he put money in at the very beginning when he sold it and it was sweat equity, they've said this is no such thing as sweat equity and they own the whole company. Well, that's to be decided at binding arbitration. And the transfer to Miss Kenochi, his widow, they're also questioning that, saying that they should be able to buy Howard's shares. instead of having a legitimate transfer between husband and wife, deceased husband and wife. These are issues that will be addressed probably at the mediation and resolved, and the binding arbitration, if not, right after that.
Thanks. Yeah, I don't want details of the case, just like the theory of the case. So that's perfect. Thank you.
I just had a quick comment, Mr. Chairman. This is Member Nylander. Yeah, I'm impressed with the quality of the report. It's very tidy and taking what is catching up on some of these issues that kind of we now know we're lingering out there. And I'm glad you're in an arbitration forum and arguing those cases there and not in front of us. So we'll look forward to seeing you after those are resolved.
I'll be back.
Yes, you will. We look forward to the next chapter in this book.
Thank you, Chairman Douglas and the board.
Thank you very much for the report. We move along.
Chair, we'll move on to agenda item number 7. This is the consideration for approval to extend the final inspection deadline of February 5th, 2022 that the board voted to impose. There are 3 requests today. I will now turn this over to Chief Gilbert, who heads our administration and licensing. Who will go through the 3 items in front of the board for possible action today. Chief Gilbert, when you're ready.
Thank you. Good morning, Chair, members of the board. Steve Gilbert, Chief of Administration for the record. I'm here today to present agenda item number 7, which consists of petitions submitted by Eureka New Gen Forms LLC, Wellness Connection of Data LLC, and HSH Lion LLC.
Excuse me, please. I'm very sorry to interrupt. This is the court reporter, and I'm having a very difficult time hearing Mr. Gilbert.
Test. Better.
Chief Gilbert, that is a little bit better. Just if you could speak up, the volume may be low, but maybe scream a little bit
better.
That's a lot better. Court reporter, is that all right?
Yes, I think that's much better. Thank you very much.
Right. Thank you.
Good morning, Chair and members of the board. Steve Gilbert, Chief of Administration for the record. I am here today to present agenda item number 7, which consists of petitions submitted by Eureka New Gen Farms LLC, Wellness Connection of Nevada LLC, and HSH Lion LLC to extend the February 5th, 2022 deadline to receive a final inspection by the CCB. The 3 licenses listed submitted petitions to the CCB to extend their deadline to receive their final inspection. The documentation that was submitted related to the delays ranged from legal disputes, county moratoriums on cannabis, COVID-19 delays, supply and labor shortages. I'll be going through each license separately, and I'll start with agenda item 7A, which is for Eureka New Gen Farms LLC. Eureka New Gen Farms LLC, New Gen, was issued a conditional medical cultivation and production license C-186 and P-122 on April 11th, 2018, and a conditional adult use retail store license RD-290 on December 5th, 2018, all within the Eureka County jurisdiction. On December 12th, 2020, the Cannabis Compliance Board issued a notice to New Gen that its cultivation, production, and retail store facilities must be inspected and approved for final licensure by the CCB, and it must complete appropriate local government requirements no later than February 5th, 2022, where the license will expire. On August 2nd, 2021, New Gen, through its legal counsel, submitted a letter to the CCB requesting an extension of the February 5th, 2022 deadline for an allowance of additional time to perfect the license. In the request, management indicated that after receiving the conditional license from the state, Eureka County implemented what they believe is an invalid ordinance banning all marijuana establishments within the county. Council also provided a copy of the Eureka County Ordinance, which is Chapter 60.050, which states medical and recreational marijuana establishments are prohibited use on all lands within Eureka County. Staff has communicated to NewGen that there are no areas of concern, and it appears that NewGen has demonstrated that an extension may be appropriate due to its efforts to perfect the license and the limitations in Eureka County. I am available for any questions, and my understanding that Michael Tangreen is present today, and Katie Helen McConnell is present via Zoom to give a brief presentation and address any questions you may have.
If we can have the presentation by the licensees and whether or not there's any existing or possible court challenges.
Thank you. Good morning, Chairman. Good morning, Chairman Douglas and members of the board. My name is Katie McConnell. I'm an attorney located in Elko County, Nevada, and I'm representing Eureka NewGen Farms. The report that was given is an accurate depiction of what NewGen has gone through for the last few years. I would just like to give a few key dates. In 2018, NewGen first approached Eureka County about being placed on a commissioner's agenda to discuss the business plan. This was after an ordinance was enacted after NewGen had applied for and was granted the provisional certificates to operate cannabis facilities in Eureka County. NewGen is the only license holder currently licensed or having a provisional certificate in Eureka County. NewGen made public comment at a meeting in 2018 and then was allowed to make a presentation at a Board of County Commissioners meeting in September of 2018. At that meeting, the Eureka County Commissioners stated that they were not inclined to consider any kind of change to their ordinance unless federal law changed. In 2019, NewGen again addressed the board regarding the plans for the facility and the progress that they'd made. In 2019, the Department of Taxation informed NewGen they could no longer move forward with the final licensing due to the moratorium. In 2020, we contacted the Eureka County Commission to request to be placed on the agenda with a proposal to amend the ordinance to an actual zoning ordinance that would allow NewGen to operate in the northern part of Eureka County, close to the Elko County line. The commission did not respond. NewGen then went to a meeting, made public comment, wherein the board, with no agenda item, informed NewGen that Eureka County does not intend to consider any type of change to the county ordinance unless federal law changes. Throughout 2020 and 2021, we have attempted to contact the commissioners directly, their legal counsel, the district attorney, as well as placing requests to be placed on the agenda. Finally, we received a letter from the chairman of the commission directly that said we were denied the right to be put on the agenda without a meeting of the board, and instead that the board is not interested in considering any type of change to their ordinance unless federal law is changed. At this point in time, the only option we believe we have is to file or institute legal action against Eureka County, which my office has been working on and plans to file within the next 2 weeks. We're requesting an extension of time to perfect the licenses so that we may institute this action for declaratory relief with respect to Eureka County's ordinance. Michael Tangreen, who is the owner, 100% owner of Eureka NewGen Farms, is also available for any questions or comments.
Sir, anything you wish to add?
I'm Michael Tangreen, owner of Eureka NewGen Farms. It's just been a struggle. We've had a lot of contradicting information. At one point in time, we was told that we may be able to move it about 1.5 miles into the city of Carlin. And so we prepared to do that. I have Lincoln Lynchfield from the City Council of Carlin with me here today. And we would just like an avenue to be able to get open and maintain compliance.
Board members with specific questions.
I have a question for staff. Did you, Mr. Staley, did you reach out to Eureka the commission and see what their thoughts were? Or no, I'm sorry, Steve, Mr. Gilbert. Did you reach out to them? Are they planning on passing an ordinance allowing this?
That's Steve Gilbert for the record, a member, Durrett, and staff did not reach out to Eureka County. We reviewed the documentation that was submitted by NewGen.
So in essence, you are asking the state for us to move the date to allow you to pursue whatever remedy you may have by possibly going to court if Eureka is not speaking with you about this issue.
Yes, that's what we're asking. We have tried to work with the county on all levels that we can possibly try, including the commissioners directly, the district attorney, and they won't even return phone calls and emails. It took 6 months to get a letter response to a request to be on the agenda. So without some communication or willingness for them to respond to us, we believe our only action is legal action. And just for the commission's kind of to understand where we're coming from, where the proposed site for this facility is northern Eureka County, near the Elko County border and I-80, far away from the town of Eureka, which is pretty much the only heavily populated area within Eureka County. Eureka County is very, heavy on agricultural, except with the exception of the gold mines that exist throughout the county. So there aren't a lot of heavily populated areas if the concern is for being away from citizens. But if you review what the comments were when we did get in front of the commission, it was basically, we don't support marijuana. And the ordinance is an all-out ban on all marijuana establishments and facilities. It does not have any zoning qualifications or any avenue that would allow us to perfect these licenses.
Let me ask another question. So if it's in a very rural, unpopulated area, who would your customers be? Would you be trying to attract customers from across state lines?
No. So where this sits is right in the middle of I-80 between Winnemucca and Elko or Reno and Salt Lake City. So the customers probably would be interstate customers and local customers. We're not close to a state line, probably close to 300 miles from any state line.
Mr. Chairman, this is Member Nylander. Where are you at on the deck relief action?
We have it prepared. We have not filed it yet. Partially trying to figure out where to file. If we just file in Eureka County and then get assigned, I think that's the appropriate venue, but get assigned a senior judge, because obviously Eureka County is really small. There's 2 district judges dealing with those time constraints, but we have it drafted. And then we were contacted about this, and so have working on preparing for appearing in front of the commission, and then I would say we'd have it filed by the end of or middle of October 15th.
And how long do you anticipate that matter will take before you get a ruling? I know that's a crystal ball question.
Well, I mean, due to senior judges and COVID and all the issues, and candidly, it depends on which judge you get assigned when you're in the rurals, like we are. Some of the senior judges are very fast. They'll do Zoom hearings, they'll do everything. And then some of the ones that we get just move a little bit slower. So I would say at a minimum a year, just based upon how slow the courts have been going in general. But DECLA relief is faster. That's the avenue that we're choosing to take. We think that's the appropriate avenue. So hopefully we would get a hearing on within the next 9 months. But at least Elko County, we're going back into kind of COVID protocols, dealing with a lot of shutdowns. And so I hope that doesn't stall us more, but I think it probably will.
Thank you.
I have a related question to that. What would the grounds be? Because the local governments aren't required to allow cannabis use, and they're not required to communicate with you about their grounds for it. So what would the grounds for your action be?
that the ordinance is an all-out ban. It's not a zoning ordinance. It doesn't have anything to do with health, safety, and welfare, zoning, anything along the lines of those requirements, but that it's just a complete ban, and it doesn't offer any way for, it doesn't leave it to localities like some of the other jurisdictions have allowed. I think the applicant, a few agenda items before, says, the city of Winnemucca is now allowing it. There are no incorporated cities outside of Eureka County. So we proposed an amendment to say that a marijuana establishment could not be within 20 miles of any township, which is what we really have in Eureka County. But at this point in time, they're denying the right to use or to perfect the license at all.
Are they not allowed to do that under the state law? I believe they're allowed to do that. They're allowed to ban it. That was left up to the local governments.
It's our interpretation that they are allowed to enact ordinances with respect to zoning, but not a complete ban unless it had to be centered on zoning or the health, or that otherwise, it says a state or local agency occupies, owns, or otherwise restricts, but it doesn't say, I mean, my interpretation was, it doesn't say an all-out ban, that they could implement control measures. But not prohibit.
Any other questions of staff or council licensing?
Sorry. So if they don't ban it and they just don't allow for it, then you still wouldn't be able to have a facility there. Correct? If they don't enact a zoning ordinance that would allow you to have it, then you'd still be in the same situation, even if they weren't banning it.
I don't think so, because it wouldn't be prohibited. So if it's not prohibited, because Eureka County doesn't have the same building codes as, say, a city would have. It's basically just a set of county ordinances. And so actually with Eureka New Gen Farms, we got to the point of, the facilities are being built and we just need that county sign off. Well, we can't get it because there's a complete moratorium. So if there wasn't the moratorium, then at least according to our communications with the Department of Taxation prior to the Cannabis Commission, is that then we would be allowed because it's not prohibited. So right now it's complete prohibition, not just measures to enforce and control, or but it's a complete moratorium and prohibition against all portions of the county. So it does not allow them to perfect their license. So I guess if your question is if they took away the complete moratorium, would we be allowed to perfect? And I think that we would, because there'd be nothing prohibiting that.
Thanks.
If there is no further questions, we probably need to take this separately. So if anyone has a motion, we have.
I do have one more thing that I would like to add. Regards to our location, the nearest township is the city of Carlin, and they're roughly 3 miles away, and they would support fire, ambulance, police, and they're totally on board with Eureka New Gen Farms being in their community. And do you have any questions for Lincoln Lynchfield from the city of Carlin? Okay, thank you.
So I have a motion, and I'm not sure if it's going to succeed or not, but it would be to bring this back in a month and allow the parties to brief that issue of whether or not the local governments can do.
I think that's something should personally, I think should be up to the court, not to us.
So I will not make a motion. I will just express my thoughts are that we do not give a continuance, because an extension. It was clear that Elko was not going to allow cultivation, or that the county wasn't going to allow these facilities, and the investment was made knowing that. And I do think local governments have the ability to not allow them. So I think you'll end up in the same spot after a couple of years of litigation. But I will not make a motion on that. I just wanted to express those thoughts.
Speaking for myself, this is Chair Douglas, I would approve the extension, allow them to go forward, to go to court, see what the legal folks say in this. And we would get clear precedent together. And it will help in some other areas in the state that have similar issues. But that's
Chairman.
any other
This is
thoughts?
Member Young. I had a question for probably Director Klimas, if that's okay. And that is, do you find that the counties that are prohibiting cannabis are moving towards legalization or allowing, or are staying fairly, staunch with denial? What the general trend is.
Thank you, Member Young. This is Tyler Klimas for the record. And since the CCB has been here, I mean, I think we've seen essentially two jurisdictions go from somewhat of a prohibition to allowing. I think it was mentioned Winnemucca was one of those. Chief Gilbert, there may be another one. I've not seen it go the other way. So if you were going to ask me if there was a trend, I would say the trend would be, relaxing some of the prohibitions. However, I don't think the sample set is that large, but I do feel that's the way that we're seeing them moving. Chief Gilbert, did you want to add anything to that, or is that an accurate depiction?
Steve Gilbert for the record. Yes, that's an accurate depiction.
Other thoughts for consideration?
Mr. Chairman, this is Member Nylander. I think the applicant has met its burden today. They've shown that in good faith, they've made attempts to activate the license, and they've run into these local issues. And I recognize that every county in Nevada is different in respect of how they have to adopt their ordinances and various regulations in respect of zoning. So I would be in favor of granting an extension for a 12-month period so that they can have their day in court in respect of these potential zoning issues, and that the license would then, have at least have a potential to be activated if they're successful with their deck relief action.
Thank you. Anyone else? It's just, that's a decision. Any other board member? Hearing no other discussion, does anyone wish to offer a motion? If we have a motion, the item just dies.
Mr. Chairman, with respect to item number 7A, Eureka New Gen Farms, I would move that the board grant an extension of time for a 12-month period from today's date.
We have a
This
motion.
is Member
Do we
Young.
have
I would second that.
the motion? We have a second. Any further discussion? Hearing none.
I just want that to let the board know that I am going to be a nay, and it's going to be the first time we didn't have an unanimous decision. So I want that memorialized. Thank you for letting me express my concerns with it.
With that, all in favor of the motion presented for the extension, please say aye.
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 Opposed?
Nay.
Read for the record. Thank you. Carries. We can now move to the Wellness Connection of Nevada, item B.
Yes, agenda item 7B is for Wellness Connection of Nevada LLC. Wellness Connection of Nevada LLC, Wellness, was issued a conditional adult use retail store, RD 633, on December 5th, 2018, within the Las Vegas jurisdiction. On December 12th, 2020, Cannabis Compliance Board issued a notice to Wellness that its retail store facility must be inspected and approved for final licensure by the CCB, and it must complete appropriate level government requirements no later than February 5th, 2022, or the license will expire. On August 18th, 2021, Wellness, through its legal counsel, submitted a letter to the CCB requesting an extension of the February 5th, 2022 deadline to November 4th, 2022. In its request, management outlined the circumstances surrounding the approval of its special use permit by the Planning Commission and subsequent denial. Wellness is currently in a legal dispute with the City of Las Vegas over what it alleges to be biased and discriminative decision-making regarding special use permits for retail stores. Staff has communicated to Wellness that there are no concerns. It appears that Wellness has demonstrated an extension may be appropriate due to its efforts to perfect the license and their legal dispute with the City of Las Vegas. I would like to note to the board that in my memo, a 12-month extension was suggested in error, and Wellness's request for a 9-month extension appears to be appropriate. I'm available for any questions, and my understanding is that Christopher Rose and Matthew McClure are present today to give a brief presentation and address any questions you may have as well.
The licensees or the representatives are present. We would like to hear from them.
Good morning, Chair Douglas and members of the board. My name is Christopher Rose for Wellness Connection of Nevada. With me today is Matthew McClure. He is Wellness's general manager. He's been their general manager since they opened their first location in 2018. And as the board has heard, this is our request for an extension of the final inspection date. Just to give a little background, the circumstances leading to this request arose from an application for a special use permit in the city of Las Vegas, which is where this provisional certificate was granted. The location where Wellness is seeking to open its dispensary is on the corner of Sahara and Fort Apache. It's in Summerlin, in the area of Ward 2 of the city of Las Vegas. And we note that there's no dispensaries currently in Ward 2. As we've presented, there was overwhelming support from the public. The city's notification process resulted in 10% of those who received the notices approving and supporting it, and 98.2% of those who received notices had no opposition whatsoever to the dispensary at this location. There were also a number of, I think, in excess of 1,500 petition signatures. There were two issues from a broad standpoint, two main issues that led to the dispute and the litigation with the special use permit application process. The one was that, in Wellness's view, the application and hearing process was unfair and biased. What happened was there was a council person who took a public stance against the application for several months leading up to it, had advocated against it, publicly requested that the special use permit application be withdrawn, and had also solicited members of the public to oppose the application, to appear at planning commission meetings, at the city council meeting, had communicated and requested that constituents do that. So that was the first problem that Wellness believed happened in this process. The second was the disparity in how these applications for special use permits have been handled. The application process and—
For the record, Chair Dunn, you've been to the city, they denied your request, correct?
That's correct.
And the grounds that you're putting forth, and you've been to the district court.
We have been to the district court.
And the district court supported your position, if I'm correct?
It did.
And what did the city do then?
After the district court issued its writ of mandamus and order for judicial review, the city of Las Vegas filed a petition with the Nevada Supreme Court in December of last year. That has gone through briefing as Wellness also filed a cross petition for additional relief. It's been fully briefed. It was fully briefed as of July. We requested, made a motion, and the Nevada Supreme Court granted the motion for an expedited decision, given the importance of these issues. That was granted, but there was no specific time frame that was set forth for when that decision would be rendered.
That was my next question. Whether or not you had a date for an argument, or whether or not they did not respond in terms of when they would decide.
Yeah, they did not, and there currently is no indication as to whether there will be oral argument or what that date would be. So the reason for the request is to allow the decision process with the Nevada Supreme Court to unfold, to run its course, and then also, depending on what that decision is, to provide the additional time that might be necessary for any further proceedings, and finally to complete the build out in the event the special use permit is granted. And that's the basis for the request. And we believe there would be extenuating circumstances for that.
Questions by our board members? If we have questions, do we have a motion one way or the other? This is a strange situation. We have a decision by the district court. It's not been enjoined. City's not taking any action. The matter is now before the Supreme Court. From the report and the oral statements today, it's been briefed up. So waiting on a decision by the court. We don't know where it'll go thereafter, but that's the status. Today's action is no more than to allow the matters before the court to play out and see where we go from there.
Yes. And Chair Douglas, I will add one point. After the district court issued its order, it did grant the city's request for a stay of that order pending the writ proceedings.
I'm going to move to approve, and I just want to state that I think this is distinguishable from the last case because this is already ensconced in litigation. You've already gone through the litigation. You have a very viable case. It looks like it's very likely you could prevail. And again, with the last one, I think these deadlines need to be respected because they're part of the entire structure of this program. They were the first things put in place in this program 6 years ago. So, but I would move to approve this one because it is because you have already been battling this issue. You didn't locate in a place where it was never going to happen. You're just having to deal with a very limited issue. So I move to approve.
We have a motion for approval of the extension. Do we have a second?
This is Member Young. I will second that.
We have a second, if I understand. With that, any additional discussion? All in favor, please say aye.
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 For the record, any opposed? Motion carries. Thank you very much.
Thank you.
Thank you.
That will take us to item number C.
Chair, I have a disclosure regarding item 7C. I can give that disclosure now or after Chief Gilbert has given his presentation. Any preference?
We need to hear what you have to say in terms of.
Okay, perfect. That's why I just wanted to. In regards to item 7C, I have a disclosure in that I have a physician-patient relationship with one of the managing members, Mr. Ernst. I have cleared with him that I can disclose that relationship. I do not believe that it will affect my ability to render an objective opinion, as it is a purely professional physician-patient relationship.
Right. With that, any board member wish to ask anything additional before we proceed with what's placed in front of us? As to this item, if you would just kind of give us an overview of the report that you prepared for us.
Yeah, thank you. Agenda item 7C is for HSH Lion LLC. HSH Lion LLC, HSH, was issued a conditional medical cultivation and production license, C-187 and P-123, within the Lyon County jurisdiction on April 11th, 2018. On October 12th, 2020, the Cannabis Compliance Board issued a notice to HSH that its cultivation and production facility must be inspected and approved for final licensure by the CCB, and it must complete appropriate local government requirements no later than February 5th, 2022, where the licenses will expire. On August 10th, 2021, HSH submitted a letter to the CCB requesting an extension to the February 5th, 2022 deadline to October 2022. In its request, management outlined the facts surrounding the initial delays to their build-out and how the COVID-19 pandemic caused unforeseen delays, including supply chain and labor issues. In the timeline of events, HSH provided to the CCB on August 12, 2021, it described its progress since August 2017. The timeline outlines its purchase of a site, working with Lyon County to obtain conditional use permit for its facility, and the many supply chain, labor, and economic roadblocks it encountered due to COVID. As of January 2021, HSH has secured financing, received updated bids for the project, and after the initial ETA of October 2021 for the metal building, now we're being told to expect delivery in December 2021 or January of 2022. Management does not feel that they will be able to direct the building before the February 5th, 2022 deadline. Staff has communicated to HSH that there are areas of concerns. The areas of concern include HSH has owned the land for its cultivation and production facility since August 2017. The moratorium on cannabis in Lyon County was lifted in March of 2018. HSH has had a conditional use permit since November 2018. From the timeline supplied by HSH, it appears it did not make any progress on the build out of its facility for the majority of 2019. HSH indicated that management evaluated its facility build out in July of 2020, but decided to wait, claiming the cannabis industry was still slow due to COVID. Staff researched cannabis sales based on taxable revenue statistics, and only 3 months in 2020 experienced lower sales than in 2019. All other months showed an average increase of approximately 24%. From the timeline supplied by HSH, it appears it has not made any progress on the build out of its facility for the majority of 2020. The concerns are that HSN has made limited progress on the build out of their facility, and it appears that an extension may not be appropriate. I am available for any questions, and my understanding is that Ashley Ernst and Russell Ernst are present today to give a brief presentation and address any questions you may have as well.
Thank you.
Good morning. I'm
Ernst,
Ashley Ernst. This is Russell Ernst.
You would make your presentation and give us, if you can, specificity of some kind of timeline looking to deal with this. We understand there's problems, but we'd like to hear what you're trying to do to get this matter going.
So I'll kind of start from the beginning and then kind of move forward to kind of where we are today. We did purchase the land in 2017. There was a moratorium in Lyon County Russ and one of our other managing members did work with the county on that, and they got it through Lyon County. They were one of the counties that had a moratorium on it. We did finally get most of our plans done in 2019. We do have all of the greenhouses that we plan on putting on there. We have paid for all of it. The problem is we are also a local company. We do have another grow and production facility up in Reno. We also did we were not vertically integrated. We are currently working on becoming vertically integrated. So the problems that we did run into with COVID, and even though the retail sales were up, is that it was much harder for us to sell our product to other dispensaries. So last year when COVID shut everything down, we were having a couple of good months, and then the rest of the year we were probably down. At least the first couple of months we were doing maybe 25% of what we were doing, probably back up to maybe 50% to 75% towards the end of the year. Unfortunately, since we are a local group, we do have to secure the funding. We aren't lucky like some other groups that are publicly traded. So this project is looking to cost us about $10 million. We cannot just ask for $10 million from a large corporation. So we have been trying to put together currently a dispensary in Lyon County, and then along with the grow in Lyon County. As you can imagine, this year as well, have run into some supply issues. We have continually tried to get our building, which keeps getting pushed back on us. We have put down a down payment on it, which we are happy to provide the receipts if anyone wanted to see them. But we're trying to move forward with it, but we keep running into roadblocks with it as well. So that's part of the reason why we're asking for the extension, just to try to get this done. We know Lyon County is excited to have it on there as well, because they do have the revenue stream from that as well. So that's kind of where we are at with it. I don't know.
No, so.
Questions by members of the board?
Mr. Chairman, this is Member Nylander.
Yes, sir.
So when will this building that you've ordered, when will it be built?
We're hoping that it's supposed to come in. The last time we heard is was supposed to be in physically to our location by December or January, but we've been told that to get everything done correctly, which is what we would like to do the first time, it's going to take us about 3 or 4 months to get it up. We are asking that we get extended out to October of 2022, because we feel like that'll at least be able to get those final licenses.
Well, I have some concern because this has been since 2017, really, the plan anyway. I think the legislature limited these number of licenses for a reason. They wanted to have a robust industry, and they didn't want people to have licenses and have them just be sitting around, which affects revenue for the state and growth in the industry. So I have some concerns, but I have a question for Director Cannabis, if I might, Mr. Chairman.
Yes, please.
I know that historically we have granted these on a 12-month basis, but are we bound by that, or can we grant a shorter period of time?
It is my understanding, Member Nylander, this is Tyler Climers for the record, that the board can grant a shorter period of time. Council's here if they would like to correct me, but yes, I believe that is, and you're right.
Okay, thanks, Mr. Chairman. That's the only question I have right now.
And I guess to kind of speak on why we do hold another license, we have another cultivation and production that we've had since 2016. We're also trying to open up currently the dispensary. So this is kind of why it's taken us longer to get this one going. We do want to get it going. We do want the revenue stream, of course, for Lyon County. That's why we worked with them to do it. So it's not our goal to keep it being a plot plant. It's been a different market from not being, I guess, vertically integrated was harder. So we're hoping now that we will be vertically integrated. We have the revenue stream to sell the product, because it is becoming tougher in the market.
No, no, and I appreciate, what you're trying to do. And obviously I want you to get it right the first time too, because otherwise you won't pass your final inspection. We'll be back here again. So, but no, and I do appreciate that. And I do know there are supply chain issues that are affecting everyone right now. But I'm going back to 2018 when none of this was going on. And even in 2020, there just doesn't seem, at least our report indicates, there really hasn't been much activity. So I want to impress upon you the fact that as a board, we're responsible for making sure these things move along. So, it's an important issue, and I just want to stress that upon you.
And we feel that we want to get it done. We want to get it open. It's been on our goal. We've had the plans made for it. So we were pushing to get it done. I'm not gonna lie, 2020, it doesn't look like a lot because it really did put a wrench in everything. I mean, we had months with our own grow where we were just like, they were still had to put money back into it because, we weren't having the sales. So that's why it does look like that, especially in.
Thank you.
Member Drett, I have the same concerns as Member Nylander. I'm probably less generous than him because I think these were probably business decisions that were made, and you were able to successfully open and operate the other facilities. And so you probably just, this one wasn't as big of a priority for your investments. And I don't think the publicly traded companies just struck it big or out of luck. A lot of these were local groups. Most of them, the original owners were local Nevadans, and they made a lot of sacrifices to be able to meet these deadlines. And then later, some of them were purchased by publicly traded companies, but it didn't happen overnight. It was a lot of sacrifices that were made early on.
For the record, this is Chair Douglas. As to the issue for us right now, I'm looking at it as was stated, the history of, I'm willing to support probably 6 months to have it back before us, to see where we're at. If we don't see any signs of any kind of progress, it would be difficult for me to support any continuation. That's where I'm at this. So with that said,
Mr. Chairman, I'm in support of your comments, and I'm prepared to make a motion for a 6-month extension when you call for it, if you call for it.
With that being said, anyone else wish to weigh in? So if they're reading where the more concerns. All right, we've discussion. Then do we have a motion as to this request?
Mr. Chairman, with respect to agenda item 7C, HSH Lion LLC, as reflected on the agenda, I would move that the board grant an extension for a 6-month period from today's date.
Member Merritt, I will second.
We have a motion, we have a second. We have any additional discussion? Hearing none, all in favor, please say aye.
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 No dissents. Motion carries. 6 months extension on the day's date.
Thank you very much.
All right, Chair. With that, we'll move on to agenda item number 8. This is approvals and resolutions. We have one agenda item today on a notice of final licensure for Rural Remedies LLC. Chief Gilbert, you are still on the mic, and you can start when you're ready.
Thank you. Agenda item 8A is an informational item presented as a notice to the board of establishments that have been issued their final license since the last board meeting. We have one to note today. Rural Remedies applied for a conditional medical cultivation and production license during the January 2018 application period held by the Nevada Department of Taxation and was granted a conditional license on April 11, 2018, C-192, P-127. Rural Remedies applied for a corresponding adult use cultivation and production license during the October 2018 application period, also held by the Nevada Department of Taxation, and was granted a conditional license on February 8th, 2019, RC 192 and RP 127. These conditional licenses were granted for a site in Austin and Lander County. Rural Remedies also applied for conditional medical cultivation and production licenses during the 2018 application period, held by the Nevada Department of Taxation, and was granted conditional license is on April 11, 2018, C193 and P128. Rural Remedies applied for corresponding adult use cultivation and production licenses during the October 2018 application period, held by the Nevada Department of Taxation, and was granted conditional licenses on February 8, 2019, RC 193 and RP 128. These conditional licenses were granted for a site in Battle Mountain in Lander County. On May 20th, 2020, staff conducted a pre-opening inspection and audit of both facilities located in Austin and Battle Mountain. The inspection at both locations revealed some deficiencies that were not in compliance with the regulations of the Nevada Cannabis Compliance Board and/or Title 56 of NRS. 2 statement of deficiencies were issued on August 14th of 2020 for the 2 locations. Rural Remedies corrected the deficiencies, and an approved plan of correction letters were issued on June 29th of 2021. As a result, the CCB approved and issued final license to Rural Remedies LLC on September 10th, 2021 for 1 medical and adult use cultivation and 1 medical and adult use production in Austin, Nevada, and 1 medical and adult use cultivation, 1 medical and adult use production facility in Battle Mountain, Nevada. With that, Chair, members of the board, I'm happy to answer any questions.
The board, any questions based on the report? This was on for discussion. If there's no questions, we can move the agenda.
Great. We'll move on now to agenda item number 9. This is an item that's been on the agenda before. This is the consideration of suspended enforcement of NCCR 13.025 due to COVID-19. This is known as the 2-driver rule. With that, I will turn it over to Deputy Director Michael Miles to preview this item once again for the board.
Good afternoon, Chair and members of the board. For the record, my name is Michael Miles, Deputy Director of the Cannabis Compliance Board. During the July board meeting, the board approved an amendment to NCCR 13.025, Section 5, to change the circumstances in which 2 drivers are required to distribute cannabis. Also, at the August board meeting, the board granted emergency relief to the 2-driver rule due to Blackbird Logistics' problems with the COVID-19 surge and had waived the 2-driver requirement till today. Blackbird Logistics is requesting another extension to the enforcement of the recently amended regulation. Staff is present to answer any questions the board may have, and I believe a representative of Blackbird Logistics, Drea Ballard, is present via Zoom to make the request.
Before we get into questions, Representative from Blackbird.
Hi, good afternoon. My name is Dre Ballard. I'm with Blackbird Logistics. I'm the Director of Operations for Nevada. And Blackbird is just suggesting and recommending that we continue to extend this relief from this rule due to the continued advisement of the CDC to remain 6 feet apart, which would be impossible in a vehicle traveling together for extended periods of time.
Questions by board members?
This is Member Young. I have a question. Are you mandating vaccination?
We currently are mandating vaccination for all newcoming onboarded employees. We are requiring testing for all unvaccinated employees, and currently our company vaccination rate is over 80%.
This is Member Nylander. When the company appeared before us last, there was a outbreak at the facility that I think it was at the transportation facility. What does that look like now?
Currently, we have one employee who is out for COVID protocol. We would say that the outbreak is over, and we contribute that to our safety measures that. So we have full social distancing in all of our locations, and this measure would definitely hinder that objective.
And are you requiring masks now? Because I know that at the time of the outbreak, one of the representatives indicated that the relaxing of the mask rule, which everyone was doing at the time, they felt that in hindsight may have been a mistake, as that may have been part of what led to the outbreak.
We currently require masks for all operations employees, on-site, off-site, in every dispensary, every license location that they travel to.
Okay, thank you.
As to the drivers you presently have, do we have issues with wearing of masks or vaccinations or anything else, or what's going on?
Was that a question if our drivers had issues with vaccination?
Well, just in general, what is the status of the people who are driving for you present?
So our total company vaccination rate is over 80%. I believe our Las Vegas staff is still in the 65% vaccination rate. And there are various people in the process of getting that. So we're seeing that continue to rise, but I don't think that we'll meet 100% vaccination rate. I do believe we will, as a company, be following any suggestions that come down from government. And if a company of our size is required to, mandate vaccination, we will move towards that. But currently, we don't.
Thank you. Other questions by any board members? Any discussion as the proposal? Chair Douglas, for the record, myself personally, we have granted a number of extensions. We have a jurisdiction that's been trying to move forward on this issue. I'm not inclined to want to grant another extension. So others wish to weigh in, being for or their position.
Sorry, Mr. Chairman, this is Member Nylander. You cut out there for a minute.
I was not in favor of another extension, but if someone else wished to make an argument for, I'm willing to listen.
I don't remember if the amended rule, we delayed the effective date of the rule. Is that correct?
Mr. Miles?
We just weren't enforcing the rule until today.
Okay, so the rule has been gone through all the processes to make it effective. We just elected not to enforce it.
Correct.
And would you restate the new rule? I think we came up with a distance requirement.
You're correct. We changed the rule to the product in the vehicle has to be worth over $75,000 to require two drivers, and they have to drive a minimum of 100 miles between stops before two drivers are required.
Great. Thanks for refreshing my memory on that. Thank you. Well, Mr. Chairman, I'll weigh in real quickly. I think we've granted a number of extensions on this. The rule has been hashed out. We've heard a great deal of testimony. I think it was appropriate last time around to grant the extension. The company and others similarly situated were having outbreaks, but now it seems like at least enough time may have passed that the new rule should be effective. In my view, I don't think granting the extension is going to cause damage to the licensees at this time, and I think the licensees have now had time to develop their business plans, which Blackbird has done. They may not like the rule, but I think we've already voted on the rule. The rule's supposed to be effective earlier, so I'm not in favor of granting another extension. I think the rule should be generally applicable as we go forward.
I think, again, for the record, Chair Douglas, let me not get ahead of myself. Are there any other discussions? I think in all fairness to the industry as well as this licensee, I would make a motion to enforce the regulation we have properly voted on at the end of 30 days.
I would second that motion.
Allows a licensee to facilitate his business operation, not bring undue hardship. So we have a motion. Do we have a second?
Mr. Chairman, this is Member Nylander. I would second the motion.
All right. For clarity of the record, I've made a motion. Seconded. All in favor, say aye.
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 Any opposed? Any opposed? Motion carries. So with that, we'll move our agenda.
Okay, so we'll now move on to agenda item number 10. This is the Cannabis Advisory Commission updates and actions, very similar to the last month. And since the last board meeting, these subcommittees that we discussed have begun to meet. They have continued to meet, discussing some of the nuanced issues around consumption lounges as they prepare to develop just some recommendations that the board will be able to consider through the advisory commission as part of the promulgation process for setting up consumption lounges. So from my perspective, I'm very pleased with the work that's been done, and certainly appreciate public and industry feedback as we go through these subcommittee meetings. As far as the greater commission, we're likely looking at the end of October or sometime in early November for the next advisory commission meeting, which they will consider some of the work that's been done by the subcommittees. So any questions from members of the board on the Cannabis Advisory Commission? Oh. All right, let's move on to agenda item number 11. This is the briefing to the board from the executive director. I've got a small handful of things to discuss today. The first is I just want to recognize the CCB enforcement team. They have recently participated in an effort to eradicate and shut down a large cultivation grow that was on land, tribal land in Douglas County recently. This was in the news. This effort was led by the U.S. Attorney's Office in conjunction with the DEA, Homeland Security, and the FBI, as well as the Bureau of Indian Affairs on the federal side, and on the state side, the Douglas County Sheriff's Office, the Nevada Department of Public Safety, and the Cannabis Compliance Board. So I just wanted to recognize that and thank our enforcement team. Obviously, these partnerships that we have with the federal government and our state partners are very important. And so I just wanted to be able to recognize those efforts today. Moving on some federal affairs, earlier this week, or excuse me, last week, through the Cannabis Regulators Association, which as you know, we helped form which is a group of 35 state regulators, submitted comments on the Cannabis Administration and Opportunity Act. We had talked about this at the last board meeting as well. This letter and the subsequent comments touched on state authority, minimum standards and consistency, data monitoring, revenue, and social equity. Those comments are public, and I will keep the board up to date on anything else with the CAOA. I think it's going to be, it's going to take some time for that bill to make its way through Congress, but we'll update the board accordingly. Sticking with federal affairs, recently we did receive notice that the Safe Banking Act, the safe banking language, did make it, probably unsurprisingly, into the NDAA, so the Defense Authorization Act. On the House side, it is somewhat significant. I mean, that bill, the safe banking, has passed the House multiple times with bipartisan support, where it's always hit a roadblock in the Senate. But it has found a vehicle, at least from the House side, to move forward. Next steps for that would be a conference committee with the Senate staff on the NDAA. I mean, it's likely going to meet the same resistance that it had on the Senate side anyway, but we'll see what happens. But I will update the board on that as well. Moving on to regulations, a couple items to note here. On regulation 11.015, this has to do with lab payments. At the August board meeting, this regulation or proposed regulation was up for adoption. Chair, you had asked to hold it back while we had council look and analyze some of the comments that we received on that regulation. Council has analyzed that, and we will be moving forward with adoption of that regulation at the next, I believe at the November board meeting, giving time to notice that. The second regulation is the remediation regulation, 12.065, an update on that. That was set for consideration at today's board meeting. However, after last board meeting, when the language was proposed and discussed by Member Young, we did receive quite a few comments from the public on that particular regulation. And so we feel that we would like to put that on the next scheduled workshop, allowing us time to receive even additional comments now that that language has been released. So there won't be a special workshop for that, but we will have a number of upcoming workshops on a number of different issues, and we will put that on there and certainly notice the public when that is available. And then finally, just as an FYI for the board, the Department of Taxation released its taxable sales information for the fiscal year. And I think it's important to note that taxable sales for the cannabis industry in Nevada exceeded $1 billion for the first time for fiscal year 21. That's up from $650 million last fiscal year. Obviously, that includes a couple months during COVID or at the beginning of COVID. That resulted in, through excise taxes, around $150 million to the state. That's up from $100 million for the last fiscal year. So just wanted to make sure the board was aware of those. So, Chair, that's all I have for the report. Happy to answer any questions on any of the items that I discussed.
Question by board members. Okay. With that, the money keeps coming in. Moving our agenda along to item number 12. Next meeting date is October 26, 2021. Unless something changes, that is our proposed date. And any members of our board have any items for future agendas? Item 13. Moving along then, we have second public.
Great, thank you, Chair. So agenda item number 14 is public comment. Start again in Las Vegas. Is there anyone here in Las Vegas wishing to provide public comment? Please come up to the podium and state your name for the record.
Good afternoon. My name is Amber Jansen. I'm not really sure where to share this, so this is why I'm coming to you guys, but I've been in the industry since 2016. So I'm very familiar with the laws and how cannabis works in Nevada. However, I don't think a lot of people from out of state or even locals know how to identify a dispensary here in Las Vegas. for whoever's in the industry, it may seem very easy. You have a CBD store on Fremont Street labeled a dispensary. I happened to go in there on the weekend of Life is Beautiful. They were making customers think that they're buying THC. I didn't know how to address it while I was in there, but I could see people were buying it. And honestly, from the questions they were asking, I could tell they thought they were buying THC. So I asked very publicly, hey, is this a CBD store? And I said it loud so everybody would hear me. And they're, oh, we have a lot of CBD dominant products. I said, okay, let me ask you this. Is there enough THC in any of your products to get me high? And the lady really quietly told me no, but she did it very quietly. When I went outside, there was a couple that I had heard talking to the lady and they had purchased while all this had happened. So when I went outside, they're already smoking their joint, right? And I said, do you think that has THC in that product that you just purchased? And they're like, well, yeah, it's a dispensary. I said, unfortunately, it's not, it's a CBD store. I don't know how you would, I don't think it's your regulation, but I think something should be done because that's frauding customers and it's not a fair business practice. And, you know, it doesn't look good for our state either, because how many people are going to go back home and say, yeah, I bought cannabis in Vegas and it wasn't any good. It didn't get me high, whatever it was. I don't think it's a fair business practice. I don't know if maybe taking away that word dispensary from regular businesses would help, but it's just something I wanted to bring to your attention. Thank you.
Thank you.
Is there anyone else in Las Vegas wishing to provide public comment today? All right, we'll go to Carson City. Is there anyone in Carson City wishing to provide public comment today? Please come up to the podium when you're ready.
I see no public comment on Carson City.
Great. Thank you. Back to you, Chair.
That chair is willing to accept motion for adjournment.
I move to adjourn.
We are adjourned. Thank you very much.